everyone, it's Elena, and today I'm going to talk to you guys about the Human Rights Act 1998. Before Parliament passed the Human Rights Act, the UK was already a member of the Council of Europe, so that meant that the UK already had an obligation to follow the European Convention on Human Rights and international law. But the problem was that that obligation only existed at the international law level. So that meant that if you were a citizen within the UK and one of your convention rights was violated in the UK, you couldn't go to a UK court to enforce your convention right. Instead, you had to take your case to the European Court of Human Rights in Strasbourg. And getting your case heard in that court takes a long time because the court has a lot of cases. And so the UK Parliament wanted to make it easier for people to bring a case to enforce their convention rights. And that's why they passed the Human Rights Act. So today we're going to take a look at the main provisions of the Human Rights Act and how it has made it easier for people to bring a case for their convention rights. But please remember that there is a lot more to the Human Rights Act, and these are by no means all the important provisions, but this is just a main outline of what you definitely need to know about the Human Rights Act. So let's get started. Now, since you had to go to the European Court of Human Rights for a case for a convention right prior to the Human Rights Act, the Human Rights Act also accounts for any jurisprudence that is created by the European Court of Human Rights. So under Section 2 of the Human Rights Act, national courts should take account of any Strasbourg jurisprudence. So what that means is that national courts should take a look at any decisions that were made by the European Court of Human Rights that are relevant to the case before them when coming to their decision. In the early time after the Human Rights Act came into effect, national courts thought that this meant that they had to follow the Strasbourg jurisprudence, but not more, not less, and just, exactly align with it all the time. So that was the mirror principle, and we can really see this in the case of Ullah, where in the judgment it said that the duty of national courts is to keep pace with the Strasbourg jurisprudence as it evolves over time, no more, but certainly no less. So they wouldn't develop the jurisprudence surrounding any convention rights by themselves, but they would always follow Strasbourg. Now, the thing with the convention rights, the European Convention on Human Rights, is that they evolve over time, as is acknowledged in the judgment in Ullah. And that means that the European Court of Human Rights can expand their definitions over time as is appropriate according to the court. But national courts soon realized that just following the Strasbourg jurisprudence wasn't enough, because sometimes definitions had to be expanded because standards in societies changed and the way we view things changed, and the Strasbourg court simply hadn't had a case yet where they could expand the definition, but the national courts wanted to expand it because it was appropriate. And you can see that in the case regarding G, where the House of Lords said that they could go further than the Strasbourg jurisprudence, but in this case it was also very likely that the Strasbourg jurisprudence would develop into this direction, so the national court was willing to go further than Strasbourg had gone at that point in time. Now, Section 2 of the Human Rights Act requires national courts to take account of Strasbourg jurisprudence, but that doesn't mean that they always have to follow it. They do have to take it into consideration, but they can depart from it. And we can see this in the Horncastle case, where a UK court departed from Strasbourg jurisprudence. And the reason they gave for it is that the Strasbourg jurisprudence insufficiently appreciated or accommodated the domestic process. But it's rather rare that a court will depart from Strasbourg jurisprudence, but the Strasbourg court has actually also acknowledged after the Horncastle case that sometimes this may be necessary, because after all, the European Convention on Human Rights is an agreement between many states, and some of the national legal systems may not be able to accommodate everything of Strasbourg jurisprudence, but they may have other ways of protecting the convention rights which were simply not recognized by Strasbourg jurisprudence yet. So that's why the Strasbourg court also acknowledges that this mirror principle, which we first seen in Ullah, also accommodates occasional departures from Strasbourg jurisprudence. Now, some scholars think that UK courts aren't going far enough in, how independent they see themselves when it comes to interpreting convention rights. So, for example, Lord Irvine called on courts to actually consider the cases before themselves more independently and to take account of Strasbourg jurisprudence, but to really take more of a lead in developing the jurisprudence around convention rights on a national level. Whereas, for example, Phillip argues that actually the mirror principle already accommodates this possibility because it allows departures, and he thinks that the courts, as they are currently dealing with the convention rights, are actually following what was intended by the Human Rights Act, since the Human Rights Act does say take account of, so it does mean look at the Strasbourg jurisprudence, but it doesn't mean always follow it. Whereas Lord Irvine thinks that the Human Rights Act actually wanted the courts to be a bit more independent than they currently are from the Strasbourg jurisprudence. So now we know what courts have to take into account when they are making a decision on a convention right. But what can they exactly do if somebody brings a case because their convention rights were violated? The key provisions for this are sections 3 and 4 of the Human Rights Act. Now, under section 3, if a court hears a case that is brought under the Human Rights Act, they should try to construe the legislation in question so far as possible to do so as compliant with the convention rights. and only if that is not possible we are moving to section 4. Now there's a really important limitation to this, and that is so far as possible to do so. So that means the courts shouldn't make up, any impossible interpretations, but they will actually take that interpretive power quite far, as we have seen in different cases, but only if it is really impossible for a court to construe the relevant legislation to be compliant with the convention rights, then they will move to section 4. Now it's really important to note that when I'm talking about legislation, I mean primary legislation, so acts of parliament. The courts have no strike down power over acts of parliament, so that's why they may construe them in a way that makes them compatible with the European Convention on Human Rights, but they can't simply, change the entire text of legislation, because that would really offend the sovereignty of parliament and its ability to make law. Now, if the challenge that is brought to the court concerns secondary legislation and not primary legislation, the courts may be able to declare the secondary legislation unlawful, but it really depends on how that secondary legislation came into being. So if there is a secondary legislation that violates a convention right, but this violation of the convention right was authorized through primary legislation that then, conferred that power to make the secondary legislation on, say, for example, Secretary of State, then the court cannot strike it down, although it is secondary legislation, because the violation of a convention right was authorized through primary legislation. But if the violation of a convention right is not authorized through primary legislation, the courts may be able to declare it unlawful. But let's get back to cases which concern primary legislation. Now, before we take a look at section 4, which is really a section of last resort to say so, let's first of all take a look at how section 3 works in practice. Mark Elliott and Robert Thomas broke down the stages of analysis that a court goes through when it considers section 3 in relation to a challenge under the Human Rights Act in their textbook, and I think it's a really useful breakdown of stages, so I thought I'd share it with you guys here. So they break it down into 3 different stages. So the first stage is that the court considers the natural meaning of the legislative provision. So they look at it and they ask themselves, okay, if we take the normal meaning of these words, what will be the meaning of this legal provision? And then they ask themselves that if they gave this legislative provision its natural meaning, would it be compliant with the European Convention on Human Rights, or would it indeed violate a convention right? If the courts find at this stage that the relevant provision is indeed compliant with the convention rights when it's given its natural meaning, then the relevant provision is compatible with the European Convention on Human Rights. And it's honestly quite unlikely that you would get a case like this to be heard by a court, because the courts would probably dismiss your case because they would be like, it's really obvious that this is compliant with the European Convention, so why do you want to bring a court case about this? So very likely they're going to move on to stage 3 in the analysis. And stage 3 only happens when in the first 2 stages they couldn't find that provision to be compatible with the convention rights. So then they ask themselves if in some way this provision could be read in a way which would then, if it was given effect, make it compatible with the convention rights. And if they can make that happen somehow, they will. Because so far as possible to do so, they are allowed to interpret legislation to make it compatible with the convention rights. Now, you may think that this provision, so far as possible to do so, is actually quite restrictive, because how much further than the natural meaning of words can you really go? Now, the courts have actually proven that they can take this power quite far, as you can see in the case of Ghaidan and Godin-Mendoza, and I'm really hoping I'm pronouncing these names right. In this case, the relevant legal provision made very clear reference to the gender of the beneficiaries, and it was very clear that whoever should benefit from this provision should have been the wife or husband of that person, or should have lived with them like a wife or a husband. But the person who challenged this provision was somebody who had been in a same-sex relationship, and so they couldn't have lived with their partner like a wife or husband at the time, because same-sex marriage was not legalized at that point in time. And although that provision has very clear references to gender and quite clearly implies that this is only about opposite-sex relationships, the courts took their interpretive powers so far to include same-sex relationships in that provision. Now, if the courts really can't use this extensive power under Section 3 because the primary legislation is just so clearly incompatible with the convention rights, then they have to go to Section 4. And Section 4 authorizes the courts to issue a declaration of incompatibility. So if the courts find it impossible to find an interpretation of the relevant legislation that makes it compatible with the convention rights under Section 3 of the Human Rights Act, then they go to Section 4. And under Section 4, they can then issue a declaration of incompatibility. And that basically means that the court says this legal provision is incompatible with the convention rights. Now, this doesn't change the legal situation between the parties in this lawsuit. it doesn't do anything for them. It doesn't give them any remedies. It doesn't change anything for them. It only says, you are right, it is incompatible, but as a court, we can't strike down primary legislation, but we can give you this declaration which says it's incompatible. And then there are mechanisms for Parliament to fastly respond to such declarations of incompatibility if Parliament would like to act on it. But for the moment, such a declaration doesn't change anything in the legal situation of the people in this lawsuit. One example where the courts used their power to issue a declaration of incompatibility is the Anderson case. But as I already said, that is only a declaration of incompatibility, but Parliament acted on that declaration of incompatibility and the law has changed since in order to be compatible with the Convention rights. And although these declarations of incompatibility don't have any legal effect, they actually have a lot of power because most of them are acted upon by Parliament, because it is quite embarrassing for a Parliament in a democracy to be told your legislation is incompatible with the European Convention on Human Rights. It just sounds very bad. And Parliament also wouldn't have passed the Human Rights Act if they hadn't intended to be compliant with the European Convention on Human Rights. So that's why most of the declarations of incompatibility that are issued are also acted upon by Parliament, and the law is then changed. Now, if these declarations have such power, you may ask why they haven't simply given the courts the ability to say, this is incompatible, we strike down this legislation. That's because that cannot be accommodated within the constitutional arrangements of the UK as they are currently seen. And the main principle here is parliamentary sovereignty. So in the UK, Parliament is sovereign. That means whatever Parliament enacts as law, the courts have to follow. And they may interpret and construe it in different ways, but they can't strike it down, because if the courts had a strike down power, the courts would be above Parliament. But that doesn't work because Parliament is sovereign, putting it above all the other actors. So that's why they can't strike down acts of Parliament. The other thing to consider is the doctrine of separation of powers. Now, that doctrine isn't strictly followed in the UK, but still there are some elements of the separation of powers doctrine that we can see within the constitutional arrangements of the UK. And under this doctrine, every branch, so the executive, the judicial and the legislative branch, have, their own spheres in which they work, but they shouldn't be overlapping each other. Now, obviously that isn't very strictly followed because we do have quite a bit of overlap. I mean, the most obvious example is that the executive, so the government, usually controls Parliament because they usually have a majority in Parliament, but Parliament is the legislative body, so we have a lot of overlap there already. But under this doctrine, the courts have an interpretive role, so they shouldn't be making policies and they shouldn't be making legislation because that is the job of Parliament. And yes, Parliament may have help from the executive, but the courts shouldn't be doing that, and there's quite a few reasons for that. One of them is that the courts aren't democratically accountable like Parliament. So if the judges were to make laws by striking down acts of Parliament, nobody would be able to hold them accountable for these decisions in the next elections because they can only vote on their members of Parliament. But they can't say, well, this judge, he struck down this act of Parliament, but I thought that was not good, so I'm not going to vote for him. It doesn't work that way because you don't have a vote about those judges anyway. So that's why although the doctrine of separation of powers isn't strictly followed in the UK, it is still relevant, especially when it comes to the Human Rights Act and what it allows the courts to do and what it does not allow the courts to do. One last thing that's really important to note about Section 4 is that Section 4 is an authorization for the courts to issue a declaration of incompatibility. It does not require the courts to issue a declaration of incompatibility, and the courts may actually decline to issue that declaration of incompatibility, even if some of the judges think that the relevant legislative provision is actually not compatible with the Convention rights. An example of this is the Nicklinson case, where the Supreme Court declined to issue a declaration of incompatibility for various reasons. One of the reasons that played into it is that the Nicholson case concerned a very controversial topic, which is whether there is a right to die, and the court simply said, well, we as a court, we can't make the call on that because that is a policy issue, and Parliament has struck some balance in this, and we can't deal with this because really this is a controversial issue where Parliament should have the last word. But there were a lot of different reasons in the Nicholson case. It's a great example of a lot of different reasons being given by different judges, but it's a really good example for showing that the courts don't have to issue this declaration of incompatibility and that they may actually decline to do that. And yeah, those are the things which I think are the most important things about the Human Rights Act when it comes to revising for your exams. Obviously obviously that is not everything that the Human Rights Act does. There's a lot more. And lastly, I just quickly want to say that of course if you bring a case under the Human Rights Act, you obviously need to point to a convention right that has been violated, and I would really recommend going through the convention rights in your statute book just to make sure that you know where they are and you know have a good idea of what they are, because it comes in handy when you're doing problem questions, just so you can quickly go to your statute book and refer to the right convention right. But yeah, those are the things which I think are most important about the Human Rights Act. And one last thing that I want to point out is that it's really important to know that the Human Rights Act is not the only protection of fundamental human rights within the UK. So the common law has also developed several fundamental rights, and I think one of the cases which really clearly illustrates that the courts are saying, yes, the Human Rights Act is one way of protecting human rights, but the common law also has some ways, is the Osborn case, where the claimant actually wanted to bring a challenge under the Human Rights Act, and the court said, well, you know what, actually you don't need to go through the Human Rights Act because the common law recognizes this fundamental right. So actually under the common law, you can already challenge this. So you don't need to go, you know, through the entire procedure of the Human Rights Act and go through section 3 and section 4. Instead, just argue your case based on the common law. And so yeah, the common law also recognizes some fundamental rights. There's a lot of debate surrounding this theory about how much the common law actually accommodates fundamental rights. If you guys would like an entire video on the common law protecting human rights, please let me know, and I hope you guys found this video helpful for your revision. Thank you guys so much for watching. Have a nice day. Bye!